Hello everyone and welcome to this video tutorial on causation in criminal law. Causation is looking at whether the defendant's acts or omissions caused the harm or the damage. And causation must be established in all result crimes. And you may be thinking, well, surely it's obvious if the defendant stabs somebody and they die, they've caused the death. And of course, in some cases, it is that obvious, and we don't have to get into a big debate about causation. However, in real life, things aren't always that straightforward. And I sometimes think of causation as being a bit like a chain of events or dominoes situation where the defendant does something and then lots of other things happen and then the victim dies. And what we have to look at then as lawyers is what the defendant did enough? Is that what caused the death, or was it one of these things instead? And we should only be finding the defendant liable for a crime if we truly believe that he is responsible and that he caused that particular result. So to prove causation for a result crime like murder, we have to prove firstly that there was factual causation, and secondly that there was legal causation. So we're going to start off with looking at factual causation. Factual causation is decided using the but-for test, which is a strange sounding sort of test, but it's what we expect from our judges. So factual causation is established by applying the but-for test. And this asks, but for the actions of the defendant, would the result have occurred? If yes, the result would have occurred anyway, so the defendant is not liable. If the answer is no, the defendant is liable, as it can be said that their action was a factual cause of the result. We'll look at a couple of cases which will illustrate how this but-for test works. Firstly, we've got the case of White, and in this case, the defendant really didn't like his mum. And so he put some poison in his mother's tea with the intention of killing her. And the mother took a few sips of her tea and she had a heart attack and died, having drunk only about a quarter of the tea. And medical tests established that the mum died not from poisoning, but from an unconnected heart failure. So in other words, she was going to die that day anyway. It had nothing to do with the poison, and in any event, he hadn't used enough poison. So he was not guilty of a murder because he hadn't caused her death. I've put here in brackets, though, he was convicted of attempted murder because obviously he's still guilty of a crime. He still tried to kill his mum. But what we're looking at here is, did he kill his mum? And the answer is no. The but-for test was not met because V, our victim, would have died anyway. And in a way, you've got to kind of feel sorry for the defendant here. If he'd have just waited another day, she'd have popped her clogs anyway, and he'd have saved himself a whole lot of trouble. But that's a side point, really. What this case is showing is the but-for was not met because she would have died anyway. So he is not the factual cause of her death. Let's look at another case then, the case of Paget. Facts of Paget were that our defendant was a 31-year-old man, who'd separated from his wife and he'd struck up a relationship with a 16-year-old girl, Gail, her name was. And 16-year-old Gail was heavily pregnant and she'd broken up with this man and he was very unhappy about it. So he kidnapped her with a shotgun. And he was trying to avoid the police. He was trying to escape from the police. And he had hold of his pregnant girlfriend and he decided to use her as a human shield. So he put poor Gail out in front of him and he started firing at the police. And he thought, well, he won't fire back because I've got a pregnant 16-year-old in front of me. Brave guy that he was. But the police, obviously under fire themselves, shot back in self-defense. Obviously, they tried to avoid Gail, but she was pretty hard to avoid at this stage. And unfortunately, they shot and killed her. Now, Paget, the defendant, was convicted of her manslaughter. And in this case, the but-for test was met because the victim, Gail, would not have died but for the defendant using her as a human shield. So he had caused her death by holding her in front of him. Factual causation then, using the but-for test. So we've looked at White, we've looked at Paget. Let's go on to consider legal causation. So factual causation alone is not enough. We also have to prove legal causation. And there are three parts to legal causation that we need to study: the de minimis rule, thin skull rule, and some exciting Latin novus actus interveniens. So we'll start off with de minimis. Minimis rule then, again we've got some Latin here, and de minimis is abbreviated from a longer Latin phrase, and it's abbreviated from de minimis non curat lex, and that means the law cares not for small things. And this is a legal doctrine by which a court will refuse to consider trifling matters. So de minimis means insignificant, minute, trifling, small. The court's not going to consider tiny little things. Essentially, it refers to something or a difference that's so little, so small, so minuscule or tiny that the law doesn't refer to it, won't consider it, and it won't be the cause of a result. So if, for example, I'm very annoyed with Jared and I decide to stab him through the heart with a samurai sword, which are very sharp, watch The Bodyguard on that. So I stab him with a samurai sword in his shoulder because I'm a bad shot, and he's bleeding on the floor. Seb comes along and thinks, oh, I hate Jared too, and gets a little compass out of his pencil case and pokes him with the tiny sharp bit of the compass. And then Jared dies. Seb is not going to be the cause of Jared's death. I am, with the samurai sword. What Seb did will be de minimis non curat lex. The law cares not for small things. What Seb did with the compass was so insignificant, so minute in the context of being stabbed with a samurai sword that we're not going to look into it. We're not going to consider it. So what we're saying here is that the original injury caused by the defendant must be more than a minimal cause of death. And in the case of Kimsey, we've got a phrase here that we want to use. There must be something more than a slight or trifling link between what the defendant did and the consequence. The second rule for legal causation is the thin skull rule, and this is sometimes called the eggshell skull rule because of an example that a judge gave some years ago, which I'll explain in a minute. But basically, under the thin skull rule, the defendant must take his victim as he finds him. And this means that if he has a particularly vulnerable victim, he's fully liable for the consequences to them, even if an ordinary person would not have suffered such severe consequences. The reason it's got this weird name, which sort of explains the rule, is a judge said, imagine that I'm a bad person that's decided I'm going to punch the victim in the head. And unbeknownst to me, the victim has a very, very thin skull, as thin as an eggshell. I don't know this, and when I punch him, his head explodes because he's got such a thin skull, and he dies because his skull's all in pieces. As a defendant, I'm going to try and argue, well, I shouldn't be liable for his death because I didn't know he had a thin skull. I didn't know he had this weird problem with his skull. A normal person wouldn't have had the whole skull explode. But the court won't accept that argument under this rule because the defendant must take his victim as he finds it. In other words, if you're a bad person taking a risk, punching someone, you have to accept all the consequences associated with that risk. So when you go around hitting people, stabbing people, they might have a bad heart, they might have brittle bones, they might have a pre-existing condition that makes what you've done to them worse because of that condition. You can't then blame it on the victim. That would not be fair. And this is illustrated in the case of Blau. The facts of Blau was that the defendant stabbed an 18-year-old girl 4 times when she refused to have sex with him, and this penetrated her lung. Now, our victim here was a Jehovah's Witness, and they will not accept blood transfusions. So she refused a blood transfusion that would have saved her life. When the defendant was convicted, he tried to argue, Well, it's not my fault she's a Jehovah's Witness. It's her own fault for refusing that blood transfusion. I didn't cause her death. It was the refusal to accept the blood that caused the death. And you can sort of see his point there. However, he was still guilty because he had to take his victim as he found her. And this is a fair rule to have, because it would be wrong if he was not guilty of an offence here just because she had this particular religious belief. You should be entitled to have whatever beliefs that you want. It is your choice whether to accept medical treatment or not, and that shouldn't be a factor when looking at whether the defendant has caused the consequence. So our defendant cannot blame a vulnerable victim. The final part of legal causation that we need to have a look at is Novus Actus Interveniens, and this is Latin for new act intervenes. And sometimes in life, there will be something that happens between what the defendant did and the end result. And if that is significant enough, we call it a Novus Actus Interveniens. It's a new act intervening. And if it breaks this chain, then the defendant is no longer responsible for the consequence. So I like to imagine the chain of causation as being like a chain with 3 links in. And let's say Lucy stabs Jared, Jared dies. Okay, and in order to find me guilty of Jared's death, this chain has to be in one piece. If, however, between me stabbing him and his death, something big enough happens, there will be a break in this chain, and then I'm no longer responsible for his death, but I would be responsible for stabbing him. But we're just saying I didn't cause his death. So it might be that I stab him, and then let's say an ambulance takes too long to get there, they bump his head on the door, they give him the wrong medication, they drop him on the floor, he's put on life support and someone pulls the plug by mistake, and then he dies. Yes, I stabbed him, but did I cause his death, or was there a break here? And there are 3 ways we can break this chain: act of a third party, victim's own act, and natural but unpredictable events. The general rule on medical treatment is that it is very unlikely to break the chain of causation, because we don't want doctors breaking the chain so that our naughty defendant gets away with an offence. And in the case of Smith, you can see the facts here. They held that medical treatment is unlikely to break the chain even when it's thoroughly bad, and reduces chances of recovery by 75%. So even though lots of bad things happened to our victim here, he was dropped, the medics gave him the wrong treatment, the medics' treatment was thoroughly bad, our defendant who'd stabbed him originally, still the cause of death. Similarly, in Cheshire, the general rule was followed. So our defendant shot the victim. 2 months later, there was a problem with a tracheotomy and the victim died. And the principle here was that medical treatment's unlikely to break the chain unless it was potent. Use that word in the exam, in causing death. So even though it was virtually healed, the defendant was still convicted of murder when this complications arose. If doctors switch off a life support machine appropriately, that will not break the chain of causation, and that comes from the case of Malsharak. Jordan is the exception to the general rule on medical treatment, and this is the rare case that shows doctors can break the chain if palpably wrong. And again, you want to use that phrase. And here, the victim was stabbed originally by the defendant, and then the doctors gave him an antibiotic he was allergic to twice and too many fluids, and it was held that this had broken the chain because it wasn't normal treatment. There were 2 separate issues and it was palpably wrong. But I can't stress enough, this is the exception. It's got to be virtually the same as Jordan before it's going to break the chain. The second way the chain can be broken is by the victim's own act, and it's a straightforward rule here. If the victim acts in a reasonable way, Roberts, the chain will not be broken. But if we think the victim has done something daft, that will break the chain. And that comes from Williams and Davies. So we always compare those 2 cases. And finally, a natural but unpredictable event such as lightning will break the chain of causation. And we will end there on that summary, and it'd be useful to pause here and take a note of it.